Hey everybody. I wasn't planning to do this because we got a live stream planned with a handful of other content creators like Cassidy, Lauren, same girl, different time, and possibly Don't Fuck with Justice. However, I couldn't ignore this. It dropped last night while I was asleep. So Wayfarer have now filed a request for judgment on the pleadings, and this is a big deal. So I'm wanted to record this just so I've got something, because I don't think I'm going to get to doing a thread on it anytime soon either, with everything I've got going on. I have got Mia with me, so if she's noisy, sorry about that. And my kids are in the house because it's weekend, so there may be some background noise I can't really avoid. Anyway, so get into this now. Plaintiff Blake Lively's second amended complaint asserts 13 causes of action arising from alleged sexual harassment during production of the film It Ends With Us and a subsequent smear campaign allegedly launched in August 2024, concurrently with the film's premiere. And I'm just going to go to, because there was the footnote in that, which says that the second amended complaint does not include a 10th or 11th cause of action, but skips from the 9th cause of action to the 12th cause of action. Also, the table of contents omits the 7th cause of action for aiding and abetting FEHA violations. So, let's go and have a look at that. So here's a table of content, and they are indeed right. There's the 5th, 6th, and then it jumps straight to the 8th. So there is no 7th cause of action. We've got 6th, 7th, 8th, 9th, and then it does indeed jump to the 12th cause of action. So 10th and 11th causes of actions are actually missing. As shown below, plaintiff fails to plead cognizable claims under California's Fair Employment and Housing Act, FEHA, and other California statutes for retaliation under Title VII, for defamation per se, and false light under either California or New York law, for civil conspiracy to commit the underlying torts. Lively's claims fail on the following grounds, among others. FEHA does not have extraterritorial application, and thus plaintiff's FEHA claims should be dismissed with prejudice. I can see in brackets they've listed the causes of action, but they've duplicated 6th. Plaintiff's claims for violations of other California statutes, including California Labor Code Section 1102.5 and California Civil Code Section 51.9, fail for the same reason. Lively fails to allege an adverse employment action, a requisite for retaliation claims under FEHA and Title VII. Lively fails to plead a causal link between her complaints of harassment and the alleged smear campaign as required for retaliation claims under FEHA and Title VII. Specifically, Lively fails to plead temporal proximity between the allegedly protected activity and the commencement of the alleged smear campaign or a retaliatory purpose. Lively fails to allege that she exhausted her administrative remedies against It Ends With Us movie, a predicate for any FEHA claim against It Ends With Us movie. Lively's defamation claims are barred by California's litigation privilege or New York's fair report privilege, whichever law applies. And Lively fails to plead a civil conspiracy, specifically a tort that all defendants were capable of committing. The allegations in Miss Lively's second amended complaint. So they go over the background here. This is what Lively's saying. This lawsuit arises from Lively's claim that she was mistreated on the set of the film It Ends With Us during the first phase of production, May 2023 to June 14, 2023, and unlawfully retaliated against for reporting sexual harassment that occurred on the set. Filming began in early May 2023. It Ends With Us movie and Lively, through her company Blake Link, entered into an actors loan-out agreement with It Ends With Us movie for Lively's acting services. And they refer to a declaration from Ellen, which, by the looks of it, it says Wayfarer is not a party to the actors agreement. So I think it looks like they're saying that she contracted with It Ends With Us movie. But obviously that's redacted, so it's quite hard to know exactly what's going on. But it does say Wayfarer is not a party to the actors agreement, which provides, and then the rest is redacted. The film was shot in New Jersey and New York, where Lively resides. Lively first complained about inappropriate behavior in May 2023. On May 26, 2023, Lively told Sony that she wanted to file a HR complaint. On production, May 2023, and production May 2023 was suspended in mid-June 2023 due to Writers Guild strikes and Screen Actors Guild strikes. During that time, May 2023 to June 14, 2023, Lively experienced invasive, unwelcome, unprofessional, and sexually inappropriate behavior. The second amended complaint details the alleged incidents of inappropriate behavior on the set in paragraphs 85 through 109. Before returning to production on November 9th, 2023, Lively presented a list of 17 protections for return to production as a condition of her return to complete the film. The 17-point list was intended by Lively to remedy the misconduct that Miss Lively and others had reported earlier that year. On November 15th, 2023, the Wayfarer parties agreed to Lively's terms, and on January 19th, 2024, the parties executed a contractual rider incorporating those terms into the unsigned May 2023 Actors Agreement. Wayfarer was not a signatory to the November 2023 rider, which was signed by It Ends With Us movies only. You can see where this is going. On January 4th, 2024, the parties participated in an all-hands meeting in New York where, according to Lively, a plan was approved for implementation of certain protections that will be adhered to for the physical and emotional safety of Miss Lively, her employees, and all cast and crew moving forward. Production resumed on January 5th, 2024, and concluded on February 9th, 2024. Neither the second amended complaint nor its forerunners identify any act of harassment that occurred in the second phase of filming, January 5th to February 9th, 2024. In fact, on January 14th, 2024, Lively assured a cast member that the inappropriate behavior had been stopped and that it's a professional set and we're getting good work. And Lively herself, in all of her complaints, did say that the second phase of filming was, it went well, there were no problems. So, on the eve of the film's premiere and release, rumours of discord on the set already swirling in the press. Accordingly, on July 31st, 2024, the Wayfarer parties contacted a crisis communication specialist to diffuse the negative publicity and protect the reputation of the film's director. On August 2nd, 2024, the crisis management team circulated a scenario planning document with a proposed strategy should Lively and her team make her grievances public. Lively contends that this was the launch of a smear campaign and that in the weeks and months that followed, the Wayfarer parties engaged in a sophisticated, coordinated and well-financed retaliation plan. According to Lively, the defendants mounted a well-funded retaliation campaign that sought to bury and destroy anyone that challenged Mr. Baldoni's brand. Based on these allegations, Lively asserts claims of sexual harassment and retaliation under California and federal law, breach of contract, civil conspiracy, defamation per se, and false light. Rule 12C permits a party to move for judgment on the pleadings after the pleadings are closed, but early enough not to delay trial. The standard for a Rule 12C motion is the same as that for a Rule 12B6 motion to dismiss for failure to state a claim. Thus, judgment on the pleadings is appropriate where, with all reasonable inferences drawn in favour of the non-moving party, the non-moving party has failed to allege facts that would give rise to a plausible claim or defence. The plausibility requirement calls for enough fact to raise a reasonable expectation that discovery will reveal evidence supporting the claim. A claim has facial plausibility where the plaintiff pleads factual content sufficient for the court to draw the reasonable inference that the defendant is liable for the misconduct alleged. Although a court considering a Rule 12C motion is generally limited to the contents of the complaint, the court may consider the complaint, the answer, and any written documents attached to them, and any matter of which the court can take judicial notice for the background of the case. Also, a complaint is deemed to include materials incorporated in it by reference and documents that, although not incorporated by reference, are integral to the complaint. Okay, so FEHA and other cited California statutes have no extraterritorial application, and you could see this argument come in really when they started to make these arguments in their response to Lively's request for, the treble damages and all the other remedies under Section 47.1. Plaintiff asserts claims for sexual harassment, retaliation, failure to supervise, and aiding and abetting under California Government Code, Section 12940. Retaliation under California Labor Code, Section 1102.5, and sexual harassment under California Civil Code, Section 51.9. The threshold question is whether FEHA and other cited California statutes have extraterritorial application, where, as here, the plaintiff is not a California resident and the discriminatory conduct did not occur in California. Failure to adequately plead grounds for extraterritorial application of state law constitutes a failure to state a claim on the merits. FEHA does not protect non-California residents such as Lively, where the allegedly discriminatory conduct occurs outside of California. California recognizes a presumption that the California legislature did not intend a statute to be operative with respect to occurrences outside the state, unless such intention is clearly expressed or reasonably to be inferred from the language of the Act or from its purpose, subject matter, or history. There's a quote in a lot of case law there, which I'm not going to do. But they basically just support what Wayfarer is saying. The employee or employer's residency is not sufficient to overcome the presumption that FIA does not apply when the tortious conduct is outside of California. And there's a lot more case law. To apply California law, the complaint must establish a substantial connection between the citus of the legally relevant conduct to California. To determine whether there is a substantial connection, courts look to the location of where the core of the alleged wrongful conduct occurred. And I'm just reading some of the quotes, a couple of the quotes here from some of the case law that they've cited, just ones that are of interest. Although the actors' agreement, and I deal with this now, because I know that the loan out agreement does state California as a choice of law, so I deal with that here. Although the actors' agreement calls for the application of California law, a contractual choice of law provision does not overcome the California statute's lack of territorial reach, which is quite important. A California choice of law clause incorporates California's presumption against extraterritoriality and its geographical limitation unless there is an indication otherwise. Lively is a New York resident. I will say, when she did her second amended complaint, which it was clearly the main purpose of that was to try and re-argue the jurisdictional claims against Jed Wallace and try and bring him back in and keep him in to this lawsuit. In doing that, I do think she has shot herself a little bit in the foot. Lively is a New York resident. The alleged acts of sexual harassment occurred during the first phase of production on the New Jersey set and in New York. Thus, the allegedly hostile work environment, which the core of the alleged wrongful conduct, was not in California but in New York and New Jersey. The second amended complaint lacks specific averments of any participation in or ratification of the harassing conduct by Wayfarer or It Ends With Us movies in California. Plaintiff alleges that Wayfarer's principals, Jamie Heath, Wayfarer's president, and Justin Baldoni, who would have authority to ratify an employee's conduct, were in New York during the filming, where they allegedly committed the acts of harassment that are subject of the complaint. Steve Sarowitz, described as a Wayfarer founder and financial backer, is a resident of Highland Park, Illinois. The complaint is bereft of any allegation that Sarowitz participated in or ratified any discriminatory conduct or adverse employment action, much less in California. In short, FIA has no extraterritorial application, the presumption against extraterritoriality applies, and plaintiff's FIA claims are not enforceable in this court. Plaintiff's claim for retaliation under California Labor Code, Section 1102.5, against Wayfarer and It Ends With Us movie fares no better. Courts have recognized that neither the express language of Section 1102.5 nor its legislative history indicate the California's legislator's intent to extend its application beyond California borders. The court contrasted these sections with other sections of the Labor Code which expressly provide for extraterritorial application, noting that, where it so desired, the California legislature provided for extraterritorial application. So that is basically saying that if there was an intention, if the legislator intended for the statute to apply beyond California, it would say so. There would be a provision for it to do so. And there is none here. In evaluating the extraterritorial application of California Labor Code sections 1102.5 and 98.6, the court must evaluate whether the alleged conduct giving rise to liability, that is, the action that created the litigation, occurred in California. As explained above, all the allegedly harassing conduct occurred in New York or New Jersey during the first phase of filming, and thus section 1102.5 does not apply. Finally, Lively alleges that Baldoni and Heath violated California Civil Code section 51.9, which prohibits sexual harassment by any person in a professional relationship with the plaintiff, specifically including directors and producers. Like its sister statutes, FEHA and Labor Code section 1102.5, neither the text nor the legislative history of section 51.9 indicate a legislative intent that the statute has extraterritorial application. And then there's a footnote attached to this. Section 51.9 was intended to fill a gap in FEHA by extending harassment claims to those in professional relationships with the plaintiff. It does not apply to sexual harassment in the workplace. The California legislature intended to supplement statutes that forbid workplace harassment, not to extend the act into employer-employee context. Civil Code section 51.9 prohibits sexual harassment in professional relationships, prohibits sexual harassment to business relationships outside the workplace. Lively alleges harassment in the workplace on the set of the film. Based on the allegation, Lively asserts claims under FEHA and Title VII, which prohibit sexual harassment in the workplace. Both FEHA and Section 51.9 cannot apply. Assuming FEHA applies extraterritorially, California Government Code Section 12960B requires that an employee such as plaintiff exhaust her administrative remedies before filing a civil action alleging FEHA violations. Similarly, to assert a claim under Title VII, a plaintiff may bring a suit in a federal court only if she has filed a timely complaint and obtained a right to sue. And then they cite, quote, more case law. Under FEHA, exhaustion of administrative remedies is a jurisdictional prerequisite to resort to the court. Therefore, failure to file an administrative charge before commencing suit is ground for dismissal of an action for violation of the FEHA. Similarly, under Title VII, failure to exhaust administrative remedies is ground for dismissal. On December 20th, 2024, Lively filed complaint with the California Civil Rights Department against Wayfarer and 10 other defendants and received a right to sue letter for the named parties. It ends with us, Lively's employer and party to Lively's actor agreement and rider is not identified in Lively's CRD complaint, and as a result, Lively did not obtain a right to sue letter with respect to It Ends With Us movie. Okay, let's go and have a look at that. CRD complaint. In the matter of the complaint of Blake Lively, the complainant, versus Wayfarer Studios, Justin Baldoni, Jamie Heath, Steve Sarowitz, Melissa Nathan, the agency group, PR, Jennifer Abel, RWA Communications, Jed Wallace, and Street Relation, and there is absolutely no It Ends With Us Movie LLC. So she did not obtain a right to sue against the entity with whom she contracted. Ouch. Accordingly, It Ends With Us movie is entitled to dismissal of Lively's 3rd, 4th, 6th, and 7th causes of action. In addition, as more than 300 days have elapsed since the allegedly unlawful employment practice, It Ends With Us movie is entitled to dismissal with prejudice of Lively's 1st and 2nd causes of action. Wow, that was a mistake. The complaint fails to state retaliation claims under FEHA or Title VII. The second amended complaint fails to plead an adverse employment action within the scope of FEHA or Title VII. Title VII provides that it shall be an unlawful employment practice for an employer to discriminate against any of his employees or applicants for employment because he has opposed any practice made an unlawful employment practice by the subchapter. To establish a prima facie case of retaliation under Title VII, a plaintiff must show that 1. She engaged in a protected activity. 2. The employer was aware of the activity. 3. The employer took a materially adverse employment action against her. And 4. A causal connection between the alleged adverse employment action and the protected activity. California Government Code, Section 12940H, in FEHA, similarly provides that it is unlawful for an employer to discharge, expel, or otherwise discriminate any person for complaining of sexual harassment or other discriminatory conduct in the workplace. And the footnote says, the employer alone is liable for retaliation under FEHA. Plaintiff attempts to blur the lines between Wayfarer and It Ends With Us movie, the party to Lively's loan-out agreement and Lively's employer. As noted, Wayfarer is not a party to the loan-out agreement for Lively's acting services or the rider. Retaliation claims against FEHA retaliation claims under Title VII are broader than under FEHA because FEHA requires an adverse action for the purposes of a retaliation claim to material affect employment, whereas Title VII more broadly defines an adverse action as any action that is reasonably likely to deter employees from making or supporting a charge of discrimination. Rather, a plaintiff must show that the employer's retaliatory actions had a detrimental and substantial effect on the plaintiff's employment. Plaintiff sustains an adverse employment action only if he or she endures a materially adverse change in the terms and conditions of employment. Examples of materially adverse changes include termination of employment, a demotion evidenced by a decrease in wage or salary, a less distinguished title, a material loss of benefits, significantly diminished material responsibilities, or other indices unique to a particular situation. Lively does not allege that she was terminated, demoted, deprived of any benefit of her employment with It Ends With Us movie, assert any act that may have blocked or interfered with a potential employment opportunity, or any other materially adverse change to the terms of her employment. And we have a footnote. The second amended complaint demonstrates quite the opposite. After voicing her complaints, Lively was ceded more control over the editing, which was not called for in her acting contract, and marketing, and ultimately obtaining an executive producer credit. One might even say that Lively was rewarded after her complaints of inappropriate behaviour on the set. And that's a fair comment. The second amended complaint includes only 3 cursory references to adverse employment action, each alleging a coordinated campaign to cast Miss Lively in a false light during the publicity and promotion of the film and thereafter. Lively's claim of an adverse employment action is based solely on the publication of negative publicity commencing in August 2024, after production ended and after discord on the set spilled into the public eye. And we have Lively's December 2024 CRD complaint acknowledges that her claims were constituted, and then we've got something redacted. And then the court should decline plaintiff's invitation to create something's redacted by creating a new standard for adverse employment actions. Plaintiff's failure to allege an adverse employment action alone defeats plaintiff's ability to establish a prima facie Title VII or FEA violation sufficient to survive a motion to dismiss. Right. The second amended complaint fails to plausibly plead a causal link between the protected activity and the alleged smear campaign. Merely pleading an adverse employment action is not enough, and a plaintiff must plausibly allege that the retaliation was a but-for cause of the employer's adverse action. So what they mean by that is I would not have experienced this negative publicity but for the actions of Wayfarer in that kind of context. Lively alleges protected activity, complaints of sexual harassment, and a public relations campaign which commenced in early August 2024, at or about the time of the film's August 6, 2024 premiere, which was the alleged adverse employment action. The complaint, however, does not link the two, much less plead that the public relations campaign would have occurred absent a retaliatory motive. Simply put, Lively fails to plead causation. A retaliatory purpose can be shown directly or indirectly by timing where the protected activity was followed closely in time by adverse employment action. Plaintiff fails to show the requisite temporal proximity between Lively's complaints and the allegedly retaliatory smear campaign. Over a year passed between plaintiff's May 2023 complaints and the August 2024 launch of defendant's alleged smear campaign. And they cite a case Grower versus UBS Financial Services Incorporated. An alleged smear campaign was launched more than 4 months after the plaintiff engaged a lawyer and more than 3 months after he resigned, and this was insufficient to show retaliation. While courts may infer such a link where the alleged retaliation occurred shortly after a plaintiff engaged in a protected activity, this time lapse exceeds the limit. And they quote a number of cases with similar outcomes. While the Second Circuit has not drawn a bright line to define the outer limits beyond which a temporal relationship is too attenuated to establish a causal relationship, the weight of authority supports the view that 10 or 12 months is too long. Williams against NYC Department of Correction. 1 year is far beyond what courts in this circuit have determined as temporally close. Lively surfaced her grievances in May 2023, and the alleged smear campaign began in August 2024, 15 months later. Even assuming that the January 4th, 2024 all-hands meeting where Lively renewed her complaints is the starting point, there is a 7-month temporal gap between her complaints and the commencement of the so-called smear campaign in August 2024. And my view on whether the time that should start from the grievances that she had in May 2023, or whether the all-hands meeting in January on January 4th, 2024, whether the time should start from that point, is the meeting in January 2024 was regarding events that took place in May, June 2023. This was not, these were not new allegations. She had the meeting to talk about things that had happened months before. The only reason for the long delay was because of strikes. So my opinion really is that the protected activity took place in May and June of 2023. In January 2024 is when they had the meeting. But Lively had control over when that meeting took place. She originally sent the list of 17 points for return to production protections in November, but didn't call the meeting until the 4th of January. Well, that's nearly 2 more months, 6 weeks. And she had the control over that, not Wayfarer. Right, where are we? To the contrary, as set forth below, the crisis management / public relations campaign designed to counter the already negative and escalating publicity spurred by Lively would have occurred and did occur in the absence of the retaliatory motive. So what Wayfarer is saying is the engagement with crisis PR did not happen because they were retaliating. It happened and would have happened anyway because Lively's backlash was so bad because of her own marketing strategies and her tone-deaf approach to a domestic violence film. So there's no causal link. The second amended complaint lacks factual allegations to directly establish a retaliatory purpose. The second amended complaint includes 2 cursory allegations of retaliatory intent. 1, that the public relations plan was embarked in retaliation for Miss Lively exercising her legally protected right to speak up about misconduct on the set. And 2, Ms. Abel, Ms. Nathan, Wallace, and Street Relations and others employed or engaged by TAG perpetrated a retaliation scheme against Miss Lively in collusion with the Wayfarer parties. This is sufficient to show a retaliatory animus or purpose. In fact, the second amended complaint's own allegations show something entirely different, that the alleged smear campaign was not retaliatory, but an effort to defend Baldoni and Wayfarer against the anticipated storm of negative publicity from Lively and her team's blistering criticism of Baldoni and his work as the film's director to conclude with the film's release. Lively cites text messages stolen from Jennifer Abel's phone by Stephanie Jones to support her retaliation claim. So Stephanie Jones is getting a shout out there. Those messages do not evidence a retaliatory purpose. To the contrary, they confirm that beginning in late July 2024, after the completion of production and after the end of Lively's acting services, Baldoni and other Wayfarer parties consulted public relations and crisis management professionals to plan how to counter an anticipated onslaught of negative publicity by Lively about a feud on the It Ends With Us movie set and the struggle over control of the production, editing, and marketing of the film. So they cite a few texts. I'll just quickly highlight a couple. There's a text from Baldoni to Abel from May 2024, which says, "We should have a plan for if she does the same when the movie comes out. It would be helpful to arm us in the case we need to refute any of the claims." The scenario planning document from August states we should be prepared should Ms. Lively and her team make her grievances public. Defendants' concerns proved precedent when, on the eve of the August 6, 2024 premiere, Lively sidelined Baldoni, instructed cast and crew members to defriend him on social media, and refused to be seen or photographed with Baldoni at the premiere, where Baldoni and his family were banished to the basement until Lively finished her pre-show appearances. The public furor, Baldoni's distress over efforts to cancel him, and Wayfarer's goal to flip the narrative and repair Baldoni's reputation are reflected in the text messages cited in the second amended complaint. Thus, what Lively characterizes as a smear campaign began the week of the premiere and was conceived and executed to counter the onslaught of negative press spawned by Lively and her team, quell speculation about an alleged rift between Baldoni and his cast and crew, and explain Baldoni's noticeable absence from joint press events and the lack of group photos at the premiere. Plaintiff, in fact, admits that the plan was not conceived to respond to any particular allegation. It was entirely about managing the public perception that Baldoni feared might follow the theoretical plausibility that Miss Lively might decide to unfollow his social media account. Planning to counter potentially negative publicity and efforts to defend one's reputation in the face of highly public criticism is not tantamount to a retaliatory adverse employment action, and plaintiff fails to plausibly plead the requisite causal link either directly or through Baldoni's efforts to manage the fallout from media stories about discord on the film set and Lively's efforts to sideline Baldoni from the film's production, editing, and marketing. Lively may not like the public criticism she unleashed, but the second amended complaint is devoid of facts that might show that these efforts to neutralize negative publicity had a retaliatory purpose. Absent a sufficient factual basis, the second amended complaint's conclusory allegations of retaliation fail to establish a prima facie showing that the Lively's sexual harassment complaint were the but-for cause of the smear campaign, as required to plead violations of Title VII or FEHA. Plaintiff fails to state cognizable defamation claims. Plaintiff's defamation claims fail under either New York or California law. Defamation requires a publication that is false, defamatory, unprivileged, and has a tendency to injure or cause special damage. The same requirements apply to false light claims. Plaintiff identifies 5 post-litigation statements by the Wayfarer party's lawyer as defamatory per se. Each refutes Lively's complaint. Lively was asserting serious and categorically false accusations against Mr. Baldoni, Wayfarer Studios, and its representatives. Lively made false allegations of a smear campaign. Lively's claims are completely false. There was no sexual harassment, and Lively has stated false allegations of sexual harassment. The second amended complaint cynically fails to note the timing of the allegedly defamatory statements. However, since the statements address the allegations in the complaint, there can be no dispute that they were made after Lively filed her claims in the course of litigation. California's Litigation Privilege Civil Code, Section 47B, creates an absolute to bar any defamation claim based on statements made in connection with a judicial proceeding. The privilege is absolute and applies to all publications, irrespective of their maliciousness. California's litigation privilege recognizes that a plaintiff cannot, on the one hand, make accusations in a court-filed pleading, and then on the other hand, use defamation law to silence any opposition. And we have footnote. The allegation that a defense lawyer's denial of claims against his or her clients is defamatory per se is antithetical to the First Amendment and a lawyer's ethical obligation to defend his or her clients, even in public statements in highly publicized action. Since Section 47B provides an absolute privilege for all statements made in the course of judicial proceedings, plaintiffs' defamation per se and false light claims should be dismissed with prejudice. Further, the litigation privilege extends to torts except malicious prosecution, and therefore Lively's claims based on the alleged smear campaign, including retaliation under the FEHA and Title VII and civil conspiracy, which are based solely on the alleged smear campaign, are absolutely privileged and for this reason should be dismissed with prejudice. New York does not recognize a common law false light invasion of privacy tort. The allegedly defamatory statements are absolutely privileged under New York law. In contrast to California, New York's litigation privilege does not extend out of court statements. So they're covering all bases. Friedman's statements, if Lyman decides to apply California law, are covered by the absolute litigation privilege, even though they're outside of the court. It's different in New York. Out-of-court statements do not are not protected by litigation privilege, so they are covering from that angle now. New York Civil Rights Law, Section 74, creates the fair report privilege, which provides absolute immunity from civil liability for defamation. To invoke the Section 74 privilege properly, defendants need not prove that the statements made at the proceeding were themselves accurate, rather all that matters for the application of Section 74 is that the article is substantially accurate rendering of what was said, even if the testimony given was not true. These statements made These statements made by counsel, to the extent that they can even be construed as defamatory, which they are not, merely repeat defendants' assertions made in court and fall within the scope of protected speech under Section 74. Counsel's other statements concerning plaintiff's motives for making her claims are statements of opinions and not subject to a claim of defamation. New York also protects statements of opinion from claims of defamation. And then we get to the civil conspiracy claims. Civil conspiracy is not an independent tort, and its only purpose is to extend liability beyond the primary wrongdoer to other tortfeasors for all damages ensuing from the wrong. To establish a claim of civil conspiracy under either California or New York law, a plaintiff must plead an underlying tort that the alleged conspirators are capable of committing. We then have a footnote. The elements of civil conspiracy are 1. An agreement between 2 or more parties, 2. An overt act in furtherance of the agreement, and 3. The party's intentional participation in the furtherance of a plan or purpose, and 4. Resulting in damage or injury. A cause of action for civil conspiracy may not arise, however, if the alleged conspirator, through a participant in the agreement underlying the injury, was not personally bound by the duty violated by the wrongdoing. So, plaintiff's pleading of a civil conspiracy is less than precise, relying solely on the conclusory allegation that each defendant committed numerous wrongful, unlawful, and tortious acts pursuant to defendant's common plan, design, or agreement. The second amended complaint leaves defendants and the court in the dark as to who conspired with whom to commit what tort. For instance, as only an employer is liable for FEHA retaliation claims, the non-employer defendants, Baldoni, Heath, Sarowitz, Nathan, Abel, Tagg, and Wallace, have no duty not to retaliate and thus cannot be liable for conspiring to retaliate against Lively. As explained above, plaintiffs' claims under FEHA, Labor Code Section 1102.5, Civil Code Section 51.9, and Title VII retaliation claims fail, as do plaintiffs and Title VII retaliation claims. There's a lot of typos in this, which I don't love. Defendants cannot conspire to commit torts that are not actionable, nor can defendants have conspired to defame Lively, as our underlying claims are privileged. The privilege which immunizes the named defendants also immunizes alleged co-conspirators. Also, the second amended complaint is bereft of any allegation that Abel, Nathan, Wallace, and Tagg were involved in the production of the film when the alleged harassment occurred on the set. Therefore, they could not, under any stretch of the imagination, be liable for the harassment or retroactively conspiring to harass Lively. Finally, the Civil Code Section 51.9 applies only to those in a business or professional relationship with Lively. The second amended complaint does not allege that Nathan, Abel, Tagg, and Wallace had any duty to Lively arising from a professional relationship, and thus these parties cannot be liable for conspiring to violate Section 51.9. These are only a sampling of the shortcomings in plaintiff's effort to plausibly plead of civil conspiracy against 10 defendants to commit no fewer than 11 torts and 2 breaches of contract. For the foregoing reasons, defendants respectfully request that the court enter order granting this motion and dismissing the 2nd through 7th and 12th through 15th causes of action with prejudice. If this is successful. This is a big if, but I have always said that if Wayfarer had filed a motion to dismiss from Lively's complaints, I think it would have been granted. Lively's got a right reply, so we'll see that. But if Wayfarer are successful, if this is granted, it would also knock out the request for sanctions under Rule 11 and Rule 3.6 because it protects freedmen's statements. And it should prevent her claim for the remedies under 47.1. So we will see, though. It is a very strong document, very strong filing. Another great job by Ellen the Great. Can't wait for Lively's response.